right, everyone. Hello and welcome to Post-Grant Review, Trends and Lessons Learned from PTAB Practitioners, hosted by Virtual Patent Gateway and moderated by Josepher Lee. Thanks so much for joining us, and we'd love to have you introduce yourself in the chat and let us know where you're joining us from. Virtual Patent Gateway founder Ashley Chung has a passion for supporting the next generation in the workplace and is committed to developing a growth mindset within VPG. Josepher Lee is a partner focusing on high-stakes IP litigation with an emphasis on patent, trade secrets, and copyright disputes at Armand Wilson LLP. He represents patent owners and defendants in cases spanning diverse technologies, including software, electronics, consumer goods, automotive technology, medical devices, and pharmaceuticals, and was recognized by Best Lawyers in its 2023 Ones to Watch list for his work in IP litigation. This webinar will be recorded for future use, and there is a 1.5-hour Virginia and Kansas CLE pending approval. Ashley will notify you when it is approved. There will be a short Q&A at the end of the presentation. And with that, I'll hand it over to Josepher.
Great. Thank you, Caitlin. Good morning or good afternoon, everyone, depending on where you are today. Welcome to our panel discussion. My name is Josepher Lee, and I'll be your moderator for today's panel. As Caitlin mentioned, I'm a partner at the litigation boutique, Armand Wilson, based in Newport Beach, California. And today we have a fantastic panel of PTAB experts that will guide us through the ins and outs of post-grant review proceedings at the Patent Office. Of course, the panelists would like to state at the outset that the opinions expressed today are their own and do not necessarily represent the positions of their respective organizations. For the audience, please do feel free to ask questions directly in the chat. We're going to make every effort to take questions as they come, but we will also reserve some time at the end for questions as well. So with that, I'd like to introduce our panelists, and I'll turn it over to them to individually introduce themselves. First, we have Jason.stach. Jason is a partner at Finnegan, based in their Atlanta office. Jason?
Thanks, Christopher. Yes, PTAB trials are a primary part of my practice. Been working on them since they first came into being. Really enjoy working on them, and I'm in the electrical practice group. I generally focus on electrical technologies, mechanical technologies, and software.
Thank you, Jason. Next up on the panel is Megan Raymond. Megan is a partner at Groombridge Wu, Bauman & Stone, and is based in their Washington, D.C. office. Megan?
Hi, yes, thank you. So maybe first to introduce myself, I should introduce my firm because I think probably a lot of people haven't heard of it. It's a new firm formed in November 2020. There's a bunch of us who sort of spun off of out of Paul Weiss. We're half women owned. We're based in DC and New York. And my own practice, I am DC based, as Josepher, you mentioned. I've been doing primarily PTAB trials and appeals from the PTAB and coordination between PTAB and district court litigation, or ITC, since sort of the early days of the PTAB. I do primarily petitioner side work for high-tech clients and patent owner side work for pharma, life sciences, bio clients, as well as some medical device work. So my practice kind of spans the technical gamut and also both sort of petitioner side and patent owner side. And I will admit, as petitioner side, I am terrified of PGRs. So I am looking forward to today's conversation.
Great, thanks, Megan. Great to have you on the panel today. And last but certainly not least, we have Megan Redmond. Megan is a founding member of eRise IP and is based in Kansas City. Megan?
Hey, good morning or good afternoon, depending on where you all are at. Yeah, to not confuse, we have two Megans with very similar last names, so this might get a little confusing, but I'm sure we can keep it straight. I primarily do litigation and PTAB work on cases. At our firm, there's a big intersection between those two, and so we typically like to have litigators and some folks typically more on the prosecution side, merging as teams, and so I tend to do that. But really excited to talk about this today. I agree with Megan, PGRs are terrifying, but it depends on what court you're in about how terrifying they are versus that court deciding your issue. So I'm looking forward to talking with you all about the intersection of PGRs and litigation.
Thank you, Megan. So let's go ahead and get right into it. Many of us know what inter-parties review or IPR, know about inter-parties review or IPRs. PGRs are less common, as we'll get to a bit later, and arguably lesser known. And so my first question for the panel is, what is a PGR?
Well, I can take that. So it's just one of the ways you can challenge patentability at the patent office. There are several ways that you can do that under the America Invents Act. Of course, most people have heard of inter-parties review or IPR. There's also derivation proceedings. Ex parte reexamination is still around. And then, of course, we have post-grant review or PGR. They're similar in a lot of ways to IPRs in that they're heard by the Patent Trial and Appeal Board, with oversight from the USPTO director. But as we'll get into, there are some differences, and that can have some very significant strategic consequences.
Thanks, Jason. And briefly, and we'll get into this in a bit more detail shortly, but what are some of the key differences between a PGR and other types of post-grant challenges, like, for example, IPRs?
I can take that. I don't know who's going next. So with respect to PGRs, the big things are that you can make 112 challenges, although we'll discuss later sort of how 112 has interplay with IPRs as well. But you can bring direct 112 challenges, written description, enablement, indefiniteness, and also 101 challenges are the other big thing that you can bring. But also just in terms of you're not limited in terms of 102 and 103 to printed publications in the PGR. And maybe I'll take this opportunity to say, I think the reason why I said at the beginning and why Megan Redmond said at the beginning that PGRs can be terrifying is that the estoppel consequences of PGRs being, whatever was raised or could have been raised in the petition are ultimately much broader, have much broader impact on litigation because there are so many other types of challenges that you can bring, and also because you don't have your sort of public use type art left potentially to use in litigation if you've gone down the PGR route. So those are the big differences. There's smaller differences that have to do with small differences in institution that we can talk about, small differences in sort of the standards for discovery and differences in terms of word length and things like that. But the big ones that I think people think about are just the types of the breadth of challenge that you can bring in a PGR that you can't bring in an IPR.
So Megan, one difference you just mentioned is the difference between PGRs and IPRs is the institution standard. The standard for institution in an IPR is reasonable likelihood. In other words, reasonable likelihood of prevailing with respect to at least one challenge claim. Now, in contrast to secure institution of a PGR, a petitioner must either show that it is more likely than not that at least one claim of the challenge patent is unpatentable, or alternatively raise a novel or unsettled legal question that is important to other patents or patent applications. And so my question for the panel is the more likely than not standard for PGRs appreciably different than the reasonable likelihood standard for IPRs? Or put another way, are they different, and how so?
I could maybe start with the technical distinction, and then I'm very curious to hear as to whether others think that there is an appreciable distinction between the two in practice. The reasonable likelihood standard is technically lower than the more likely than not standard. So the reasonable likelihood standard has been said to sort of allow for a 50-50 chance that, you know, there's something there, whereas the more likely than not standard requires a greater than 50% chance of prevailing. So, I mean, you know, if you're splitting hairs, you can be splitting hairs between 50-50 and 51%, 49%, which seems pretty small. And to me, I think the important distinction is the standard that you are writing in your brief. You know, you don't want to be writing down the wrong standard in your Pgr or having your expert apply the wrong standard. But, you know, it would be interesting to hear Megan and Jason maybe reflect on whether in practice, they think that the standards work out differently.
In practice, I don't think the boards are really treating them very differently. It feels like the analysis is the same, the verbiage is different, but I don't, to me, in, you know, the PGRs we've looked at and been a part of, it just doesn't feel like there's a whole lot of difference there. And it's such a small tweak of the language, but yeah, we haven't seen a difference.
Yeah, I think initially there was a question posed in the first chief judge of the PTAB was asked what the difference was, and Chief Judge Smith at the time, and he basically, he wouldn't put a number to it on the reasonable likelihood. He just said that it gives the board a little more discretion in whether to institute, at least as far as sort of the certainty required for institution. Ultimately, at the end of the case, in the final written decision, the preponderance standard applies in both IPR and PGR. And so, yeah, I don't see a huge difference overall. You really, if you're a petitioner, you want to clear the more likely than not standard no matter what anyway. So I don't think it's that big of a distinction, because that's where you ultimately want to land at the end of the case.
So as an alternative to the more likely than not standard, a PGR petitioner can also obtain institution if the petition presents a novel or unsettled legal question. And so I've got two questions for the panel. Number one, has the PTAB ever instituted based on this alternate standard? And number two, what is a novel or unsettled legal question?
I think that is a novel and unsettled legal question. We don't know the answer to what a novel and unsettled legal question is. And I'll credit to Megan Raymond. I'll let her talk about her research, working on a treatise that she was trying to look into that.
Yeah, I mean, we dug around looking into this just maybe about a month ago or so, before this question came up in the context of this panel, and we couldn't find any PGRs that had been instituted based on the novel or unsettled legal question standard. We did find one PGR, which was InView versus Mobile Tech, PGR 2019-00019, which is, fun to look at, just because, you at least see someone trying to get into this novel or unsettled legal question standard. But there, that argument was rejected. They argued improper revival rises to the level of novel or unsettled legal question. And the board said, no, it doesn't, because of Aristocrat and Excella Pharma. So that's what we know so far. And I'm looking forward to someone giving that another go and being successful at it.
Yeah, so it looks like none of us are aware of any instance, I'm certainly not, where the board has instituted PGR based on this alternate standard. And so it will definitely be interesting to see if the board ever does institute using this alternate standard. And hopefully that'll give us some guidance on the meaning of novel or unsettled legal question. So Megan, as you mentioned, the scope of challenges is much broader for PGRs compared to IPRs. In a PGR proceeding, the PTAB can institute a trial, not just based on, for example, lack of novelty and obviousness, but also based on ineligible subject matter 101, lack of utility, double patenting, as well as 112 issues like lack of written description or enablement. And also, unlike IPRs, PGRs are not limited to patent or printed publications and can include evidence of, for example, public use or on sale activity. So my question is for the panel, does this broader scope of challenges make PGRs more or less attractive? And how does the broader scope of challenges factor into whether to even pursue a PGR?
I will take that from a litigation perspective. I think it's riskier. I think except it depends where you are. So for example, if you have, in my opinion, if you're in the District of Delaware and you have a 101 issue, I like my odds better in the District of Delaware than I would like it there. So I think it matters, or are you in Judge Gilstrap's court in the Eastern District of Texas? And you're going to have to ultimately try the 101 issue. Would you rather have it tried by the PTAB as opposed to have Judge Gilstrap, do his post-trial if you can meet step 2, step 1 analysis. So I think it very much depends on where your case is pending and also the context of your case. The other thing that I think really plays into it is your best prior art really system art? And do you really have what you need to file the PGR, or do you need more fulsome district court discovery to make that happen? I've seen a couple of PGRs recently that I looked at and I thought, rules of evidence, I think they're a little on shaky ground. I think it's something you're going to have to prove up entirely. And if you don't have enough, I think that can be very challenging because as we know, PTAB, I almost feel like the PTAB, when they apply the rules of evidence, they do it more stringently than our district courts do in many instances. And so you really have to make sure, if we're just talking about a straight, prior art, printed publication, patent, that's an easier question. I think when it's system art, it's more challenging. I also think it's more challenging when you think about 112, because there are certain courts that I tend to think do a great job deciding 112 issues. And I think the PTAB for me has more of a mixed record as far as, panel dependent and things like that. So I think you just have to play all those factors in. I think probably everybody on this panel has had the experience where you have had like a claim or two slip through on an IPR, and then you go to a district court and you can have a 101 or 112 that saves the day. So you really got to think through to make sure everything is shored up because you won't have that opportunity with PGRs.
Yeah, I guess I can maybe I'll chime in here. And just one note, I think, Joseph, you mentioned double patenting, and just to clarify for folks out there, I think you're referring to statutory double patenting. Obvious type double patenting, I think, is probably not a go for PGRs. I know that there is a CBM from back in the day that found that wasn't a ground that you could assert. And so I think that probably applies to PGRs as well. And Megan, I like your point about the rules of evidence maybe being applied more strictly, because I think in the early days of the PTAB and still, proving up printed publications as prior art can be a real lift. And it was something that we didn't see going on in district courts. And I think to some extent, some of the district courts started picking up on things going on in the PTAB and started being a little bit stricter. But that's been sort of something interesting to track. I guess to me, sort of in terms of PGRs, Megan Redmond's point about sort of the interplay between PGRs and litigation is huge. And that's always a big consideration. But I think in the context of PGRs, because of the scope of estoppel, it's even bigger because, the last thing you want is to have to, go to trial without some good defense. And so I think, you're always looking at the big picture of, if I end up with estoppel in whatever I file in the PTAB, am I going to, what am I going to have left for the district court? So, maybe, to me, the most obvious times when you think about filing, think about taking that leap and filing a PGR instead of waiting to file an IPR, or when, a 9-month wait for the IPR makes a difference because of, a stay of litigation, for instance, if a stay is really important, or maybe you have a judge who will stay as soon as you file, a judge who's inclined to file, to give stays as soon as you file the IPR or PGR. As opposed to waiting for institution. And that might be somewhere that you say it's sort of worth the risk or the trade-off. Maybe with FinTIV, you think you're gonna, you would hit a discretionary denial issue with FinTIV if you wait the 9 months after issuance of the patent before filing an IPR. That could be an issue. Or, the question of how far along will you be in litigation to even get a post-institution stay might be, are issues that I think we're all thinking about. But, even so, sort of like how, again, how do you have a great 101 or 112 defense? Maybe you do want to bring that, as Megan was saying, maybe you want to bring that in district court. Maybe it's better in the PTAB. It depends on where you are in district court. But, just thinking about what you really have left for district court if something goes wrong, because, I think you have to think about the damages piece of the case too. If you're going to district court without, a good story in terms of your defenses, if that's the side you're on, the damages can end up being ratcheted up. It's not like all else is equal with respect to your damages case. The jury is also listening to the story of how good your defenses are. So I think that all plays in and plays together when you're thinking about, whether you take that big leap to do a PGR. I do think in the beginning there was an expectation. My sense was that there was an expectation that PGRs were going to be huge because you could file on so much, and there was sort of a surprise by some that there weren't more PGRs being filed. But I guess sort of looking at the estoppel consequences, I never thought that the PGRs would be huge because of those consequences. The early days, the CBMs were big because estoppel was narrow and you could file on lots of grounds. But the estoppel for CBMs is, quite different. It was just on the grounds that you raised rather than the grounds that you raised or could have raised.
So go ahead, Jason, go ahead.
Your comments touch on one of the distinctions that when we talk about the differences between IPR and PGR, for those who may not be as familiar, you can only file PGRs against AIA patents that were filed under the first inventor file, or that have a claim that is only entitled to benefit after the AIA triggering date. So what happens is, for pre-AIA cases, you pretty much have to file an IPR. That's the only option other than like an ex parte re-exam. For a post-AIA case, you can file a PGR within the first 9 months, or you can wait that 9 months and then file an IPR. And so you sometimes have a decision to make when something is eligible for PGR. Do you want to take the PGR? Do you want to wait for the IPR window to open later? And so a lot of these comments about timing and the stay, I think, are just driven by that timing distinction between IPRs and PGRs. Sorry, I meant to mention that earlier and didn't.
So going back to Megan, Raymond, you mentioned you raised a good point, which is that many litigants are most certainly wary of the effect of statutory estoppel. And so my question for the panel is, assuming a PGR is pursued, how does statutory estoppel factor into what particular invalidity ground to actually include in the petition? And as sort of a follow-up question, or let me put it another way, given that a PGR petitioner may only have one shot at invalidity, given the effects of estoppel, do you think a PGR petitioner is going to be more inclined to pursue, for example, more grounds than they would, let's say, in an IPR petition?
I mean, you in a sense, you can pursue more grounds because you have more space, but I think it really depends on what your best arguments are. I mean, I don't think that that probably any of us would say, like, you assert all the grounds you possibly have, right? You pick the best ones that you have and you go forward with those. So, I mean, frequently you'll see like a 112 ground combined with some prior art, and you might have, you might even use the 112 ground as a basis for breaking the priority chain. So you might see someone, a petitioner presenting prior art from an earlier safe date and maybe from a later date, assuming that there's no 112 support in the patent or family of patents. And so, they're going after a written description or enablement play, and also going after a play of breaking the priority chain, which frankly might also be required to get PGR standing to have a post-AIA patent. There's all sorts of interplay back and forth. So to me, I mean, if you've decided to go the PGR route, you are, putting all of your eggs in one basket. So you have to present the best grounds you have, but obviously in enough detail that you have everything in there, and that you've thought in advance about what the other side's going to say, because you don't want to be caught flat-footed having not presented some evidence or argument that you could have in your petition that may be improper to bring up late in the game, say in reply. So what do you assert more grounds? Again, I think it depends.
I tend to think that if you're filing a PGR, and I think this is true of IPRs too, then like you have your path to victory, right? And you picked your lane and you want to stick with it. I think the petitions that always fall flat, as Megan said, are ones that try to do too much and promise too much, and then they don't have the level of detail. I think it's much better to have a detailed petition that really lays it out, gives you lots of options, depending on what patent owner ends up doing, and then it gives you options down the road. I do think it is wise to think about the 112 issues or the 101 issue, whatever else you think you can put in there, because that's going to be less words and, less, element by element analysis. You're just going to have it focused on exactly what you're doing. But I think everyone should avoid the temptation of trying to put extra grounds in there because you have extra words, because you're going to run out of space. We all know that anytime you try to put too many grounds in there, then you're going to have to delete words or delete citations, which is trouble down the road.
Great. Thank you, Megan and Megan. Let me take a moment and pull up the slides that were prepared for this presentation. And Jason, I know you've got a number of colorful slides here on PGR statistics. Can you walk us through them and tell us what we're looking at? And can everyone see the slides?
I can see them.
Okay.
Sure. Yeah. So we mentioned that these proceedings may not be as popular as they were originally thought they would be. Some of it comes down to timing and some of the strategic considerations we're talking about today, but let's just see how popular they are. So for the fiscal year 2022, the PTO data shows that IPRs, there were 1,320 of them, but only 47 PGRs were filed, which represents 3% of the AIA cases that were filed in fiscal year 2022. And if we look on the next slide, we can see that this is the same data, but in the same time frame, but month by month. You can see at the top, the blue line is the number of IPRs filed each month, and then at the bottom, it's the number of PGRs. So a big month at the office was 6 PGRs filed, and the lowest number was 1. So these are not being filed with great frequency. The question may be, well, why are we having an hour and 15-minute discussion about them then? Why does this even make sense that we're all here right now? Well, it is the right tool for certain jobs, and it's important to know when it's the right tool. And sometimes it's the only tool. If you have an AIA patent and you need to challenge it quickly before the 9-month window runs out, you're in PGR land. If strategically that makes the most sense, then you just have to do it. That's your only option unless you wanted to do ex parte re-exam, for example. But of the IPR, PGR, PTAB trials, you might be stuck with PGR. So anyway, it's important, even though these numbers are low, they're an important type of proceeding. If we look at the next slide, we can see just these are the institution decisions. There's about 61% of the cases where institution was granted over the past year. This was as of the middle of May. Or the patent owner disclaimed the claims that were being challenged. Both of those represent successes for petitioners, so they're sort of lumped together there, where you're either moving forward with your PGR, the patent office is, or the patent owner has just given up and disclaimed the claims you wanted to cancel anyway. In about 39% of the cases, the PGR petition was denied and the case essentially ended there. If we then look on the next slide, we can see the outcomes for the past year in final written decisions. And we can see that 65% of the final written decisions cancel all of the claims. And about 20%, all of the claims are upheld. So the patent owner gets a complete victory there. And then there's a mixed result in about 15% of the cases. So as a petitioner, you're likely to get something in about 80% of the cases. But keep in mind, these are relatively small sample sizes. There aren't that many PGR petitions filed, and that many, even fewer than PGR final written decisions that come out. And by the time you get up on appeal, which is on the next slide, you can see that there were actually very few appeals that have been decided in PGR cases. This is data we update our data monthly here at Finnegan and put them on at the PTAB blog. This slide is directly from that. This one is from cumulatively through the end of March. But we can see that the Federal Circuit affirmed on every issue in close to 70% of the cases, reversed or vacated on every issue in 25% of the cases, and then issued a mixed outcome or partial affirmance in one case, which amounts to about 6% of the cases. So not a lot of history there, but you know, it's in line with what we see with a much larger number of IPR decisions coming out of the Federal Circuit, where they generally affirm at a rate in the 70s to, you know, depending on the month, it might even be 80–90% affirmance rate coming out of PTAB.
Can I ask a question, Jason?
Yeah.
Back to the institution statistics, it looked like about maybe 61% either instituted or their claims disclaimed. And I think in the last year or two, we've seen the institution rates overall in the PTAB tick up to something like, you know, 66–68%. So, you know, in your view, are the institution rates for PGRs actually a little lower? Is it just a matter of the small numbers? Do you think of the rates being the same, or there being any differences?
Yeah. I think of them as being roughly the same. I mean, we talked earlier about how it's a higher standard to get instituted, and maybe this slight difference, you know, 61% versus closer to like 68–69%, where, you know, I think the IPR institution rate is hovering. Maybe that is because of the slightly higher institution threshold for PGRs. I tend to think, though, that given the much smaller sample size for PGR filings and institution decisions, you have a much greater opportunity, I think, for groups of cases to maybe sway the statistics. So in some of these instances, there may be 2 or 3 cases that were, there was a PGR filed on 3 patents in a family, for example. And if those 3 are denied, all on the same issue, perhaps, then all of a sudden it really affects the denied numbers here. So there's lots of different ways to slice the data. I don't think of it really as that different and really any different in my mind from the IPR, the likelihood you'd have an IPR instituted, but the numbers are slightly different.
Yeah, I don't either, but I was a little surprised to see the numbers chunk lower.
So, you know, I think it's hard to dispute that PGRs remain relatively unpopular. And based on what we're looking at, it doesn't seem like the lack of interest in PGRs is being driven by, for example, institution rates or outcomes. And so why aren't patent challengers using PGRs more often?
Well, I think one of the reasons is just because of the timing that I mentioned earlier. So usually when you decide you want to file, say, an IPR petition, it's because you've been sued. I mean, something like at one point, the office had something on the order of over 80% of the IPRs that they saw had co-pending litigation. And so oftentimes you are either having discussions with the patent owner if you're going to, you know, be the defendant / petitioner, or you've actually been sued. And you know, if that's what is triggering the filing of IPRs, for example, for that to happen with a PGR, a patent owner needs to get the patent issued, and then within 9 months has to then sue someone on that patent, or, you know, wave it in front of their face, say they infringe, basically trigger someone to take enough interest to then draft the PGR petition and get that filed all within 9 months of issuance of that. Now, the most likely scenario for that to happen is you're already in litigation, maybe on a family member, and a child issues during the litigation. They want to add it to the case. You're already familiar with it. They assert that, and then all of a sudden you say, oh, we're in the PGR window. We're going to go ahead and file for the PGR. But unless you're tracking, you know, there are certain industries where you may be tracking much more closely your competitors' patent applications, maybe in the pharma world, for example, or other industries. You may have knowledge of and want to get a PGR petition drafted even before issuance. That might happen sometimes, but overall, because of that 9-month window where you have to appreciate that it's a threat to you and pull something as massive as a petition like this together, it's just a difficult thing to do, and it's kind of unlikely. And then when you couple that with all the estoppel concerns and things that Megan and Megan talked about, then all of a sudden you usually decide, well, we're just going to take our time and file the IPR when we're ready, unless you have some really pressing concern about why you need to get it on file sooner.
Yeah, and to add, I think from a litigation perspective, it's much more palatable to go and file a declaratory judgment of non-infringement. And then if you get into that and decide you want to file your PGR, I feel like that's a move more clients are willing to or typically take, as opposed to filing a PGR just because of the estoppel implications. I feel like for some reason, I think clients are, especially sophisticated ones, are more comfortable in district courts in those settings than they are with the PGR. Also, there's just, I think the other barrier of PGRs is there's not a huge pool, as you mentioned, Jason. I mean, you're kind of dealing with some of the questions and standards, and I think there's a lot of unknowns just because there hasn't been a lot, and that makes people a little bit more or less comfortable with the proceeding, and versus things that they know that you can get good decisions and good progress. But yeah, I think Jason, you're right. Absolutely, the 9-month is a big problem. But I also think that getting clients to sign on to them, given all the implications around them and the little bit of the unknown, is a little more challenging as well.
Yeah, and on the 9-month point, Jason, it sort of brought to my mind that I think PGRs, I think of PGRs as taking more time to prepare than IPRs because of the estoppel consequences. I think of sort of doing an even more scorched earth tactic for any prior art searching, and you just want to make sure that you have everything that much more in place. You want to make sure that you've really dug into written description, enablement, and all of your other defenses, and that you really understand them. I mean, you sort of want to do that anyway for an IPR, but for a PGR, it's that much more critical. So I think the PGRs do also just actually take more time to prepare if you're truly being sort of careful and deliberate about them. And this is maybe a little bit random, but I guess sort of thinking back to those slightly lower institution rates, the one thing that literally just came to my mind was the question of maybe some of those, maybe that's a slight reflection about sometimes sort of a protective PGR being filed. I think, Jason, you mentioned, the situation where you have a family of patents in litigation, and then one comes in issues and might be added to the case. And, sometimes you face the situation where you have a patent that's been issued within the last 9 months. It claims, it has a chain of priority to pre-AIA, but there's some questions about written and description and enablement. And, if you file an IPR, you're just for the audience, you're not supposed to file, or you shouldn't get instituted on an IPR if it was filed within 9 months of issuance, when you should have been filing a PGR when the patent was PGR eligible. So sometimes there's a question about whether your patent is really PGR eligible, and so there are a few instances, rare, but particularly I think if they're high stakes, where one might be filing an IPR and a PGR at the same time. Just depending on, sort of what happens with respect to a call on the priority date of the patent and whether it's pre-AIA or post-AIA.
So Megan, you brought up the topic of PGR eligibility. So, switching gears just a little bit, in addition to showing that the more likely than not standard is met, the burden is also on the PGR petitioner to show that the patent is in fact eligible for PGR. Now, the law is such that, only first inventor to file patents are PGR eligible. In other words, patents containing at least one claim having an effective filing date on or after March 16, 2013. And, determining whether a patent is eligible for PGR is pretty straightforward when the patent application was filed either before March 16, 2013, or when the application was filed on or after March 16, 2013, but without any priority claim. PGR eligibility is, it's more complex, where the patent issues from what's called a transition patent application. And so my question is, for the panel, what is a transition patent application, and what are some practice tips for establishing PGR eligibility when dealing with a transition application?
I can start if folks want. So the way I think about these is, it's a patent where you're claiming back to, to some parent applications, and so that maybe, you're the sort of the problematic patent when you're trying to think about whether to file a PGR is one where maybe it was filed, that application itself, or the patent that you're thinking about challenging, was filed, as a post AIA, after the AIA date, but it claims priority back to something that that comes from, pre-AIA times. And so, you technically aren't entitled to that earlier priority chain and, that early priority date, unless you can, unless you had written description enablement support in those earlier applications. So, you end up in a position of needing to, depending on sort of which side you're on, if you're on petitioner or patent owner side, tracing that back all the way, if you're, potentially if you're patent owner, but if you're a petitioner, trying to show that, you are entitled to break that chain of priority, essentially. And, by showing that earlier application, the pre-AIA application, doesn't have written description or enablement support, that follows along into your subsequent application. So that's, I sort of alluded to earlier, the possibility of bringing a 112 challenge in your PGR, and sometimes that has interplay with your priority chain date claims. And maybe Jason or Megan can state that in a more articulate way than I just did, but that was my try.
Well, I do think there. I'm sorry. Go ahead, Megan.
Oh, no, go ahead, Jason.
All right. There are some games that people have played with this, where you have claims that maybe aren't entitled to priority back to the earliest, a pre-AIA application. And there have been times when people have said, you know what, we're going to disclaim those from our patent. We're going to treat those as if they didn't exist, and they certainly don't exist once the disclaimer happens. So you no longer have PGR jurisdiction. You cannot institute forward, on this PGR, because there are no claims anymore that are subject, that were essentially AIA claims. The board has rejected those types of attempts, and it's a reflection in the AIA. There are certain assessments that are made in the AIA on a claim-by-claim basis, but there are other assessments that are made on a patent-by-patent basis. So if you're familiar with the time bar for IPRs, 315B, you look at, has the patent been asserted? You look at the filing date of a complaint, and you have a year to file an IPR. It doesn't matter whether the patentee asserted all the claims that you're trying to challenge, or if they only asserted one claim and you're trying to challenge different claims later. The time bar applies at the patent level. It's not looked at from a claim level. They might have asserted only claim one, but the time bar clock is ticking on every claim in that patent from that point forward. It's kind of similar in the PGR context, where if you have even a single claim that at any point was a post-AIA claim, even if that was canceled before issuance, and even if you've disclaimed it later after issuance, the patent as a whole becomes a PGR eligible patent. So you just have to be a little bit careful when you're looking at the AIA, and whether you're looking at claim-by-claim analysis or patent-level analysis. And this is one of those that's at the patent level.
So on the topic of, tips and tricks for addressing PGR eligibility, to preemptively address the argument that the petitioner selected the wrong flavor of PTAB trial, in other words, incorrectly filing a PGR instead of an IPR, petitioners sometimes concurrently file both an IPR and a PGR in order to basically allow the petitioner to to hedge its bets in the event that the challenge patent is not in fact PGR eligible. So how common, if at all, is that approach, and in what types of circumstances might a belts and suspenders approach like that make sense?
I think we've only seen in the context of when there's a big question on priority, where even maybe the team's unresolved on it, or there's disagreement between, client and the team. And so I think it is, and particularly for bigger clients, that it's worth paying both filing fees and filing both and seeing how it turns out. I don't, initially you always think, well, maybe it's going to be hard because you're going to be arguing out of both sides of your mouth. It's really not when you kind of put it all together and you say, we think it's priority based on this. If you disagree, then IPR, here you go. Strategically, we do tend to line up the two so that, we don't use different prior one versus the other. We will use similar grounds and things like that. But I think that's the major context that's coming up. I don't know another reason why you would probably file both, other than there's a priority issue and it may not be PGR eligible.
So, another question about this, when dealing with a transition application, a petitioner only needs to show a lack of support for a single claim in the priority application. That said, is it common for a petitioner to show at the petition stage that multiple claims lack support? And are there limitations to that strategy?
I tend to do belt and suspenders. So that's my preferred approach. That is your bullet, right? And so if you don't use it, then you can't use it anywhere else. And so if you don't want to just throw, weak arguments in, but if you have strong arguments on that issue, I would personally put them in.
Okay, so switching gears just a little bit, we've mentioned how the scope of challenges in the PGR is much broader than in IPRs. And so a question for Megan Redmond: how does that factor, if at all, into deciding in which forum to pursue a given type of invalidity challenge? And I know you've got some poll questions or questions for the audience, and so I'll turn it over to you.
I do. And I will say that I'm going to go from the defendant's standpoint on these, just because that's where I'm at typically. But I think it makes a big difference where you reside. Are you in Delaware? Are you in CD Cal? Are you in Northern District of California? Are you in Texas? East Texas and West Texas? I think they're a little bit different. And so I kind of wanted to do a couple poll questions, kind of like, if you have a 101 issue for, any folks joining us, what would you rather have the PTAB decide that? Would you rather have Delaware decide that? Central Cal, what? So I don't know who is Joseph, is that you or is that?
Caitlin, do you have the poll questions, Caitlin?
Oh, it's Caitlin. I know it takes a second to pull them up. And so I think, go ahead.
Oh, just to join the poll, you're going to either use your mobile phone and scan that QR code that's on the screen, or if you go to slido.com, you can enter in that number and that will take you to our quiz as well.
But essentially, or if you don't want to utilize that technology, you can just throw it in the chat if anyone has any ideas as far as what forum you would file. So say you're already sitting, for example, in ED Techs. Does someone think that's the better forum to decide 101? Does anyone have any opinions on that? Personally, if I were having to answer this question, I would probably say if I'm already sitting in Delaware, I would be probably, I know Delaware is a very long jurisdiction. Cases take a long time to get through that court. There's lots of favorable 101 rulings in that, and those judges are really familiar with it, right? This is not something where you're going to get a judge that's unfamiliar. Central California, you sometimes you have a mixed bag, I think, in that court of folks pretty attuned to patent cases and other folks who are not as attuned. And I think there's not yet really good statistics on the PTAB and 101 and PGRs that we have a good, rate that we can give our clients as far as this is what you can expect. So, but on the other hand, if you're sitting in West Texas or East Texas, I do think the analysis is a little bit different between those two. You're looking at more of a trial situation Oh, that's super interesting that someone thought, or we have folks that thought ED text to go there. But we just did a case down there, tried a jury trial. 101 was one of the invalidity grounds. And we won it before the jury and then lost it when Judge Gilstrap did his legal analysis. So that's super interesting to me. The next one would be different. For me, the results differ if we're talking about like a 112 issue. And I know that's a broad bucket and there's lots of issues you could be considering. Are folks more comfortable with the PTAB getting that right? Are folks more comfortable with, for example, West Texas or East Texas? That's one that I probably would say it's a closer call. I think we've had good success in West Texas with a lot of 112 issues, and I've had really good luck in Central California on those issues as well. And so that would, for me, be a closer call depending on what judge I had in that particular case. Obviously, we all know all cases used to go to Albright in West Texas, and now it's more of a, we got more options. So. And people love Delaware. I do love Delaware for 112 as well. So that's always a good choice. And then the last one for 102 and 103, what do folks think on where they would like those issues decided? For me, I love the PTAB for that. That's what they do. They do an excellent job deciding 102, 103 issues. We all know that they're decided by judges, except that rare case. And you're asking a jury to decide that. So for me, it's that's the easiest one to decide. It's PTAB all the way. So we all love some PTAB.
I thought the 112 result was interesting because to me that sometimes feels like you're trying to get off on a technicality. Like it can feel that way. It can be spun that way to a jury potentially. And if it goes in front of the jury, like the PTAB understands the importance of it and I think accepts it more readily than I think maybe the natural inclination might be of some who aren't as familiar with the law. So I thought that was interesting that I think PTAB maybe was second for 112 in the poll. I thought that was fascinating.
And I think that might be because of when it comes up in claim construction, when it's tied together, there's those courts that you raise certain 112 issues in connection with claim construction. Sometimes, especially Delaware, sometimes you can get the Delaware court to pull the trigger, but agree with you, if it's going to a jury, that's a really, that's rough. So.
I mean, it mostly should be going to the court, but certain ones, yeah. So yeah. I think maybe that's my headspace was in a different, was a specific subset of 112 issues than maybe others.
Yep.
And I was maybe going to flag in connection with the 101 question, just sort of, that drawing on what people learned in CBMs, because, the 101 ground was used in some CBMs and pretty successfully. So to me, I feel like I setting aside the estoppel issues of a PGR, I'm pretty comfortable and I feel pretty good about 101 in the PTAB. But I think you still want to sort of build a record of what was known in the art and things like that. But there are, I think, some good examples from the CBM days of sort of ways to build a good record to be able to bring a pretty strong 101 challenge that doesn't, just sort of feel like, what is 101? Please. And when you're into hand waving, it's not a good place to be in a PTAB, as we all know. But I do think that there's something to learn from the CBMs there, and I would recommend those as something for folks to look at if they're thinking about a PGR challenge.
So Megan, what do you think when the clients say to you, okay, well, we've got a whole bunch of PGR judges who were also former examiners and and they have a different viewpoint of PGRs on 101. We all know just because you get it through the patent office on 101 means the district court is totally different analysis, going to apply it very differently. So how would you respond to the client with concerns about, particularly I've noticed recently there's quite a few stalwarts on the panel judges who have been there a long time. Would you have concerns that the training of all those years of the PTAB at 101 would maybe undercut some of that?
I guess I feel like there's enough CBM decisions out there that, and I guess if I'm petitioner side, I would tend to trust the judges to, to look at how 101 has been analyzed in the past by the PTAB and apply that. I think, depending on how long they've been there and been at the PTAB, I think, there's been quite a lot of activity within even the board on 101 fronts and decisions that were coming out of the board on 101, and not just decisions coming out of the board from PGRs and CBMs, but also from, other appeals. And so I guess I trust that they have learned from that. I think that, when you're filing your case, you're citing, what are you citing? You're citing PTAB cases and you're citing federal circuit cases, right, as a petitioner. And I guess I maybe have more trust in them, in the petitioner side, to apply that law more similarly to how it's been applied by district courts who will go down the 101 route, and by the federal circuit and by the the PTAB in other cases.
Yeah, I think for me, the one, I agree with all that. I think my one is the representative claims. I feel like you get away with representative claims a lot better in district court. And I just don't feel like I would ever be willing to do that in a PGR. Maybe.
I agree. Yeah, you still have to go claim by claim. Yeah.
So it does take more of the analysis. And if you have one of those really horrible 49 claim patents, it's, probably better in district court than it is in a PGR anyway, but.
Yeah. All of this subject to change with the ANPRM, and if there are rules that come out that make it easier to extend your word count and all of that. Although you can extend your word count in petitions, so that is a possibility. Keep in mind, you could file a PGR and have some grounds that you're interested in including that don't fit in your space, and you can file an overlength petition with a motion to waive word count, and then file an at-length petition and ask to get the extra words. So that's that. I don't think that's been done in the context of a PGR yet, but something else fun to try.
So on the topic of 112 challenges, one difference, as we mentioned, between a PGR and an IPR is the ability to even raise 112 challenges in a PGR. But of course, that's not to say that 112 does not play a role in IPRs as well. What are some ways in which the use of Section 112 differs between a PGR and an IPR?
I can start. So, in an IPR, you can get yourself into trouble if you have an indefiniteness issue. Whereas, in a PGR, you can actually, try to take down a claim based on indefiniteness. So that's one thing. But I think what we're more talking about are sort of written description and enablement. And, in an IPR, you might have, again, a patent that claims priority, pretty far back. But maybe you have really good art, that you could use if you could break the priority chain. And so you are allowed to assert 112 in the context of breaking a priority chain in an IPR, not to directly invalidate the claims, but to break the priority chain so that you can assert art from a later date. So, it's sort of interesting because you think about not being able to do 112 in an IPR, but people have done that. And use that as a strategy to be able to bring in more art. And, it's actually, a reason why one might be given like a second parallel petition at the same time. I think that's actually one of the examples given as to why you might be able to file, why one petitioner might be able to file two petitions at the same time and have some luck. And that is that if you have a question of priority and you might be able to assert different art, you can give yourself an opportunity to do so by doing that. You might be able to fit in the same IPR, that's fine too, but you might not be able to squeeze that all in. So I think that's the main way in which we see 112 come up, the priority chain breaking, and then the indefiniteness questions. The means for claims, obviously. Can be a big issue, particularly in an IPR. Those can be a real struggle in IPRs. but then also just other claims that might be indefinite. And this is another place where sort of the interplay of litigation comes in and what's being said in litigation about, the indefiniteness of the claims. And that can cause problems in the IPR if you're not being careful.
So I think a final question for the panel, for at least for me, before we give the audience an opportunity to ask questions is, another difference between PGRs and IPRs is the standard used for additional discovery. How do the discovery standards differ, and is there really a difference in practice?
So this was interesting to me. Another thing that, how old were you when you learned about this? But there's technically, when you're talking about additional non-mandatory discovery, we're all used to talking about the Garment factors, which are what apply in IPRs. But there's actually technically a different set of factors that apply to PGRs, which are called the Bloomberg factors. They are relatively similar, but I think they're meant to be that I think discovery is technically slightly broader and more liberal in PGRs. Whether that really happens in practice or not, is another question. But you can get yourself into trouble in a PGR by, applying the wrong factors and analyzing the wrong factors. And there's actually a case on that where the board rejected a petitioner was trying to get some additional discovery, and the patent owner argued that the petitioner should sort of already be in possession of the evidence that they're asking for, which is a Garment factor concept. And the board said, no, like you're applying the wrong standard. You're applying the Garment factors, not the Bloomberg factors. So there is a series of factors that one steps through, and just have to be careful that you're applying the right set of factors to the right thing. You might be able to get a little bit more discovery, but again, discovery is so limited in these proceedings already. And there's so few PGRs that to me, to get a really good handle on what the opportunities are for discovery in a PGR is tricky. And I would not go into a PGR, if I'm petitioner side, I would not go in expecting that I'm going to get more discovery than I would get in an IPR. As patent owner, maybe I would try for something that I wouldn't try for in an IPR, perhaps, but I wouldn't put too much weight on getting more than you would get otherwise, which is generally nothing.
So given the the limited discovery and PTAB proceedings in general, do you think it's safe to say that if discovery is in fact needed to develop an invalidity ground, for example, public use or something in a PGR, that it's probably better to raise the undeveloped ground at the district courts instead?
I certainly think so. I think you have to have everything you need to prove your case the day you file your petition. If you don't have that, then that should not be your ground of invalidity. And if you really think it's a public use or a system or whatever, then you need to reserve that for litigation, because you cannot assume you're going to get anything, and you'll be held to your petition and PGRs, I think. And so it is safest, I think, to not pursue it in that forum.
I totally agree. Sometimes you can pull that together. That's been done in the context of CBMs. But if you can't get that proof assembled for your petition, I wouldn't run that ground.
Yeah, I agree. And sometimes it depends on the type of information you're trying to rely on. If it's a system art reference, it may be that the product was publicly used, but you might need to rely on something that was confidential to prove how it actually functioned. And so you run into potential protective order issues and things where maybe you got that information, but it's under seal. Those can so it's not just, do I have the information that I need? It's, do I have it in a form that I can actually use? And if it's not a form I can use, what steps do I need to go through to actually get permission to then be allowed to use that at the PTAB? And sometimes you can use that as a springboard for saying, I know this exists. I need to get out, I need you to order the production in this proceeding because I'm not getting the relief I need from the district court. But a lot of times you've got to go talk to the district court first and show the PTAB that you've at least tried to get relief there. So anyway, there's a lot of different things that can be at play there as you're trying to establish the grounds that you think you have or know you have to get it into a form you can actually use.
So it looks like we've been going just a little over an hour, and I want to leave some time for questions from the audience. So if you're in the audience and you have questions, please do feel free to use the chat function in the Zoom, or if you're using Facebook Live or something like that. And I'll go ahead and read the question or questions back to the panel. Looks like we have our first question from Kevin McNish, and the question is, assume an examiner made an on-the-record statement during prosecution that the patent you want to PGR is pre-AIA. You disagree. What are your tips for addressing the examiner's statement from a 325D standpoint?
I mean, these days, a lot of prosecution histories will sort of say we're examining this under pre-AIA, but you know, to the extent post-AIA applies, it doesn't affect the analysis, or they have some sort of wiggle room in a lot of the office actions that I've seen when it relates to this. But if the examiner did take a definitive position, then I think you need to come in with really just this was a material error, and here's how it was a material error. You know, the examiner either didn't have the right frame of mind or all the information that the examiner needed, or didn't discuss critical facts, for example, that maybe the examiner should have. And so there's no indication the examiner actually considered everything that the examiner should have considered. And at the end of the day, you know, the PTAB judges are very comfortable with the fact that examiners get things wrong from time to time. And so, you know, just maybe they did have all the information and they just reached a different conclusion that you think is wrong and that you think the PTAB will think is wrong. And you just have to go in on the material error prong as hard as you can.
You might hope that you have other grounds that sort of balance that all out at the end of the day. You know, if you have some grounds that are strong that don't have a 325D problem, you might be able to, you know, I mean, it's all a balancing act. You know, do you want to take the risk of 325D sinking everything, but you also might be able to get in, you know, a ground that has a 325D problem if you have other grounds that are strong, that aren't subject to that and aren't subject to, you know, some other form of discretionary denial and that are substantively strong.
Any other questions from the audience? Gonna maybe wait another couple seconds in case there are any questions from the live platform.
Maybe in the interim, I'll just give folks the citation for the case that I was talking about that sort of talked about the differences between the Bloomberg factors and the Garmin factors, and that's SWM versus Dyna Energetics. It's Pgr 2021-00097. And it's paper 79 from November 2022. So folks are really curious about discovery in the context of PGRs. You can look that up for fun.
Yeah, and there's the difference in which factors and what case you cite for those factors. There's also in the regulations for PGR, it's good cause versus in IPR, it's interest of justice standard. So a little bit different standard there. It's kind of like that reasonable likelihood versus, you know, more likely than not. Here it's sort of flipped though. Good cause is generally thought of as being a lower standard for PGRs to get additional discovery, as opposed to interest of justice is the higher standard in IPRs. IPR is going to be a more limited, you know, threshold for discovery. There's also another regulation though that says that you know, the moving party must show that such additional discovery is in the interest of justice, except in post-grant reviews where additional discovery is limited to evidence directly related to factual assertions advanced by either party in the proceeding. So that's actually up in where the IPR regulations are, not even in the PGR. You know, so the regulations are, you know, sort of umbrella regulations. Actually, this is in the umbrella portion. It's in 42.51. So you got to look in multiple places to try to see what standards actually apply when you're seeking additional discovery in PGRs.
So seeing as how there are no further questions, any final thoughts from the panelists before we conclude? Nope.
No, I'm still scared of PGRs as on the petitioner side.
Got it.
I'll just
Excited about them on patent owner side.
Yeah, I mean, I'll just loop back to one comment I made earlier, which is, it's not going to be the right tool for the job most of the time, and most people have, the numbers bear that out. But when it is the right tool, it can be a great tool to use. And sometimes it's really the only tool that fits your strategy. So definitely worth considering every time, and knowing all of these distinctions and this, the strategic considerations that go into it all, even if you're not always going to decide to go with PGR.
And I guess maybe what I'd add to that is, I think one of you mentioned re-exams before, but almost more whenever I'm thinking about an IPR or a PGR, the possibility of a re-exam is always in the back of my head. But I think it's actually not as far back in my head when I'm thinking about a PGR. And if I'm sort of into PGR world, that those possibilities, there are times when a re-exam might be the way that I would want to go. And there, just sort of as a heads up, that the time periods for how long the re-exams are taking have shortened quite substantially. So, you're not in a position of thinking like, oh, well, if I do a PGR, it's going to be much, much faster than if I go the re-exam route. The re-exam routes have really caught up substantially in terms of timing. You still have 325D you have to deal with, though.
All right. Thank you, everyone, for attending. And a big thank you to the panelists and, of course, Virtual Patents Gateway for hosting. It was a pleasure moderating this panel, and we'll see you next time.
Thanks
so
very
much, Josepher and Ashley and everyone for hosting.
Thank you, everyone.
Have a great day.